The chief of Charlotte-Mecklenburg Police also put some of the blame on parents. In today's briefing, he asked them to be more diligent about guns in their home.
Access to weapons for minors is way too easy in this day and age. I've had kids tell me that they could get a gun in 20 minutes if they wanted to get a gun. And that's disturbing to hear from a law enforcement perspective.
So this leads us to a big question on many of your minds tonight. Could parents in North Carolina be charged if their child opened fire at school? Our Megan Bragg verifies tonight.
After the deadly school shooting in Michigan, viewer Mollie A asked us, are parents ever held responsible when their child is the active shooter at a school? Let's verify. Our sources, the Giffords Law Center, North Carolina's Child Access Prevention Law, and attorney Gary Monty. According to the Giffords Law Center, there are no child access prevention laws at the federal level, and federal law does not generally require gun owners to safely store their guns. However, there are laws in 31 states that bar parents from allowing children access to guns. North Carolina is one of those states.
And the responsibility with the firearm is to keep it secured, particularly away from minors, and then to not do unreasonable things with the weapon that could result in someone being harmed.
Child access prevention laws, also called CAP laws, allow prosecutors to bring charges against adults if a child gets their hands on a gun. While there are no CAP laws in South Carolina, North Carolina's CAP law makes it a Class 1 misdemeanor if a minor gets a hold of someone that they live with's unsecure gun, either causes harm to another person, brings it onto a school campus, shows it in a public place in a careless, angry, or threatening manner, or uses it to commit a crime.
Basically, what the statute says is that if the minor is not supposed to have access to the firearm, and you're supposed to put it away where the minor cannot get access to it. And if you're negligent, in essence, if you're not acting like a reasonable person in terms of your storage of the firearm, you leave it out in the open, you don't attach the lock, you don't otherwise secure the firearm, and a child gets access to the weapon and then takes it to a school, you could certainly be charged criminally with that.
Attorney Gary Monty says parents in North Carolina could potentially be charged with involuntary manslaughter, elevating the charge to a felony.
Let's say they've told you they're going to go out and kill someone if they ever get a weapon, and you give the weapon or make it available to the child under those circumstances, again, to anyone for that matter, then you could be charged with involuntary manslaughter, which is a felony.
So we can verify that, yes, in North Carolina, parents can be held responsible if their child is an active shooter. Monty says, depending on the situation, more charges could be brought against the parent if a prosecutor sees fit. With your Verify, I'm Megan Bragg.
So here's what happens next at CMS. The CMS board members are meeting tomorrow night. Superintendent Winston is supposed to talk about his gun policy at that meeting. And this week, the CMS Safety Task Force is supposed to give Winston a list of recommendations. We'll follow both of those developments throughout the week.